After a DUI arrest, the officer inventories everything found in your car, your pockets, and the surrounding area. A crumpled bar receipt is just another piece of physical evidence. Beyond the scene, prosecutors can go further. They can subpoena records directly from a credit card company, a bank, or a bar's point-of-sale system. Those records can arrive in the discovery file without you ever knowing they were requested. A receipt shows a purchase and a time stamp. It does not show your blood alcohol level the moment you drove. Body weight, metabolism, food consumption, and the alcohol content of each specific drink all influence where your BAC ended up. Under Vehicle Code 23152, the prosecution must prove actual impairment, not just that alcohol was purchased. A receipt alone, without a reliable chemical test or other corroborating evidence, carries limited weight in court. A receipt can actually work in your favor in two ways. First, if it shows modest consumption spread over a long meal with food orders, your attorney can use the timestamps to support a timing of drinking argument, showing your BAC was likely within the legal limit when you left. Second, if the receipt shows you had a drink very shortly before driving, and a breath test registered high almost immediately after, that supports a mouth alcohol argument. Residual alcohol in the mouth from a recent drink can temporarily inflate a breathalyzer reading beyond what your blood alcohol truly was. Credit card statements, Venmo logs, and payment app records do not come to the prosecution automatically. They require a properly issued subpoena. Your attorney can challenge whether that subpoena followed the correct legal process and whether the records are genuinely relevant and admissible. If evidence was obtained improperly, a suppression motion may be an avenue to seek its exclusion. That procedural layer applies whenever the government builds a case around financial records. If you are tempted to contact the bar and ask them to lose the receipt, stop. Any attempt to interfere with potential evidence creates a far more serious legal problem than the DUI itself, including possible obstruction charges. Leave every record exactly where it is. Write down what you remember about the evening, note the times and what you ate, and put all of it in your attorney's hands. Do not post about it online or discuss it casually, because those conversations can come back into evidence as well. A bar tab is one piece of a much larger file. Your attorney will review the officer's notes, the chemical test results, and any witness statements alongside the receipt. Common areas of focus include whether the stop itself was lawful, whether the breath instrument was properly calibrated and maintained under the standards set by Title 17 of the California Code of Regulations, and how field sobriety tests were conducted. A receipt does not change those fundamentals. It is context, and context cuts both ways depending on what the rest of the evidence shows. Whatever that receipt says, the full picture of your case is what matters most. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.